You have an hour. Um, my apologies, Dr. Member. Dr. Member, the CEO, COMESA Competition Commission. I'm so sorry.
Okay, let's start. So, ladies and gentlemen, esteemed panelists, good morning and welcome to the plenary session 1 on evaluating effectiveness of advocacy initiatives. So, again, I'm Kenneth Tanate from the Philippine Competition Commission, and I would like to take this opportunity to thank our host, the Competition Authority of Kenya, especially to Dr. Adano and to Mr. Shaka Karaoke. So I am honored to serve as moderator for this exchange of experiences, insights, and best practices on the topic evaluating effectiveness of advocacy initiatives. So before we begin our discussion, I would like to briefly introduce our distinguished panelists. So first we have Dr. Virginia Silvestre, for my immediate right. So Dr. Silvestri has been working for the Concessions and Public Service Directorate of the Italian Antitrust Authority since 2023. She holds a PhD in economics with a specialization on market regulations, antitrust, and industrial competition. Then second, we have Mr. Ir Rosman on my immediate left, bin Abu Sama. He is a member of the Commission of the Malaysia Competition Commission, or MYCC. He is an experienced and skilled chemical engineer with over 31 years of experience in the oil and gas industry. And third, we have Dr. Willard Wemba to my far right. So Dr. Wemba is the Director and Chief Executive Officer of the COMESA Competition Commission, which regulates competition, consumer protection in the common market. He has over 18 years of experience in competition and consumer law enforcement at the regional and national levels, as well as in the development of competition and consumer protection laws, guidelines, and operational manuals in COMESA member states and beyond. And last but not the least, to my far left, Mr. Juan Contreras Delgado de Cos. He is the acting advocacy director of the Spanish National Markets, or CNMC, and heads the Public Aid and Draft Regulation Unit. He has in-depth knowledge on areas involving public intervention in the market and has overseen numerous reports on draft regulation, tender documents, and aid regimes. So our discussion today delves into the crucial role of advocacy in fostering a culture of competition and the importance of evaluating the effectiveness of these initiatives. Similarly, we will look at how effective the advocacy initiatives of young and mature agencies are in reaching and engaging specific stakeholders. So the discussion will explore the following key questions as applicable to our speakers. So one is, what were the objectives for competition advocacy initiatives that your agency has implemented in the past years? Second, how are the effectiveness of advocacy initiatives evaluated? What are the information or data are needed in the assessment? What performance metrics are being used, if any? Third, in your agency level scorecards, are there any outcome indicators being measured? And what are these? And last, are there plans to revisit or refine the advocacy objectives, initiatives, and performance metrics? So without further ado, let us explore the intricate nuances of the assessment on the effectiveness of advocacy initiatives and the impact these have on fostering a culture of competition in various jurisdictions. So our speakers have 10 to 12 minutes, so I hope I can monitor your time. So first, may I call on Dr. Virginia. I've heard that you have a very interesting advocacy initiatives vis-a-vis the policymakers. Kindly tell us about it, especially the evaluation process employed by the Italian Antitrust Authority to assess the effectiveness of these initiatives.
Thank you. Thanks, first of all, I want to thank the host for organizing this workshop. And I did have a slide presentation. I don't know whether we can project it, because I'm going to show some data as well, like graphs, and it's not going to be so effective if I just talk, maybe. Not sure. No. Okay. Okay, then I'm going to start. I'm going to talk about the how we monitor the effectiveness of advocacy opinions and interventions at AGCM in Italy. First, I want to introduce briefly the organizational structure of advocacy interventions, because it might be different from some other authorities. We do not have a centralized advocacy unit, but rather each case unit, sectoral case unit, prepares and proposes to the board advocacy interventions specific to the market to which is dedicated. Then if there are some advocacy interventions that are cross-market or broader in scope, then that will be dealt by the General Directorate of Competition. Like, for example, we issue an advocacy opinion yearly on the annual law for market and competition, or the budget law. Otherwise, the only advocacy unit, specific advocacy unit, is mine. We work on concessions of local public services. Then another brief introduction about the legal framework. Our main stakeholders are public policy makers, so the advocacy activity is addressed mainly to administrative acts. And we do have in our Italian Competition Act a specific legal framework. Thank you. Well, they will start at one point, I think. We have 3 articles. 2 of them are, so to say, for pure advocacy activities, where we issue opinions either on already existing acts, which are of particular relevance for competition in the market, but that create some obstacles somehow to competition that are not justified by the needs of general interest. And then there is another article for draft acts. Under that article, we may issue opinion also under request of, for example, the administration, or we can issue ex officio as well. And then there is another article that I wanted to talk about, because maybe it's a bit special. Not all authorities may have this power. When we detect a violation, which is not violation of an antitrust law, but violation of other laws that aim at promoting or protecting competition, then we can issue a so-called reasoned opinion to the administration that issued the administrative act. And the administration has 60 days to comply with our opinion. After this time, we will judge whether the administration actually complied or not, and if it didn't, we can appeal to the administrative court. So this is a pretty strong power that I think not all authorities have. So going to the monitoring activity that we do, of course it's somehow facilitated because we have just one stakeholder, and our focus is on the tracking the administrative acts, which may be, of course, laws, regulation, whatever, after we issue the opinion. So we are going to, our performance metric is looking at whether the administration actually changed something according to what we suggested. And that can be partial compliance or total compliance. So this is for us success. If the administration partially or totally complied, for us is a successful case. We gather many different types of information on each of the advocacy intervention. This may be, for example, which was the legal basis, what level of administration was involved, like central versus local versus a mix of the two. It may also be public companies. We collect data on what economic sector was involved, what kind of competitive restriction we found, if the opinion was given upon request or ex officio, and then another series of information like whether we issued a request for information or not, whether that was replied, whether the restriction falls under one of the OECD categories for measuring the economic impact of advocacy decisions. And all of these goes into an internal database which is accessible to everyone working at the AGCM. But otherwise, we also publish a two-year update on the results of the advocacy activities, which is synthesized, and I would really like to show you some graphs here because I had I wanted to show you the results of the last two-year monitoring update. In particular, we found, I'm going by memory at this point, we issued 169 advocacy interventions in 2021 and 2022. Of these, 69% were actually successful, which means that the administration complied partially or totally. And then we saw that there is a difference in the success rate depending on whether we addressed local administration versus central administration. Like local administration tend to totally comply more frequently. We also looked at the most addressed economic sectors. For example, in 2021, we issued many advocacy interventions in the tourism sectors because we found a lot of problems in administrative acts having to do with state maritime concessions, in particular extensions of these concessions. And another thing that we measured was we counted how many distinct competitive restrictions we addressed. There were 341 distinct competitive restrictions. The most frequently addressed one, and now I'm really going by memory, I remember it was awards without a tender, restrictions to doing business, and then there was another one. The other nice result that we got is that the advocacy interventions were much more successful when we addressed draft acts. So under Article 22, as I said, instead of final acts. When it came to draft acts, success rate was 87%, so pretty high. But when we addressed final acts, it was much lower, 63%. So, and also consider that inside the intervention for final acts, we also have the special power that gives us active legal standing before administrative courts, which not many authorities might have. So that percentage maybe could have been even lower. The main takeaways that we take from that we derive from this whole monitoring activity are exactly. So the level of finality of the act, so when to intervene. It's better to intervene earlier on draft acts rather than final acts. Then we saw that it's important to, well, it's not so effective if you intervene many times on the same issues if you weren't successful to start with. So maybe less sometimes is more. It's also important to solicit compliance in an earlier stage. So if you solicit compliance only at the monitoring stage, that might not be so effective. So we started inserting a sentence inside advocacy opinions asking the recipient to report back within a certain number of days on solutions and measures put in place to comply with our opinion. And another takeaway was that, well, of course, competition culture is central, but also having, let's say, a credible threat. So we have this threat of appealing to the administrative court, and that is quite effective, we found. Thank you.
Yeah, your advocacy is indeed remarkable, Dr. Virginia. But can I have a follow-up question on the type of data or information that you gathered in the assessment? Can you elaborate on that in terms of data or information gathered in your monitoring and assessment?
The data is exactly this. So, for example, for one intervention, you would the data we have is the administration was local. We issued it under Article 21. We issued this kind of request for information. It was answered or not. Its economic sector was, I don't know, tourism. It falls under the OECD classification. So this is the kind of data that we have for each of the advocacy intervention.
Yeah, thank you. So now let's hear from Mr. Ir Rosman. So MYCC is one of the competition authorities in the ASEAN with aggressive advocacy activities. So kindly share to us some experiences and in the topic.
Hi, thanks Dr. Kenneth and all the panelist members and all the audience. Okay, I'm Rusman. I'm from Nation Competition Commissions. So, well, my CC is just formed 13 years ago. It's quite young, and we still want to learn more from all of the senior competitions. That's why we attend all the workshop, all the conference worldwide. And in fact, last time we attend the ICN annual conference in Barcelona, and together with our chairmen. Well, as I mentioned just now, my CC is 13 years, and compared with the other, for example, Japan FTC is about 77 years, I guess, and the FTC Commission is about 109 years. So, well, nevertheless, we are still young, but we do have issue the final what we call final penalties against 5 cartel, what we call a 5 cartel, where do the price fixing for the chicken feed case, and the fine, total fine is close to $500 million ringgit, is, to be exact, about 415 million ringgit, and they have to answer to all of the allegations made to us, made to them, 5 enterprise. So they have to put in the written representation and as well as oral representation. And after we issue the provisional, what we call provisional decision. So we issue the final decision after we have, after we get all of the written representation and other representation with them. And that's one of the issue. And the other one, in fact, we issue proposed decision to 7 enterprise where do they call it bid riggings against our bid rigging in one of the tender in the Ministry of Defense. The tender worth is about 20 million ringgit, and the total fine is close to 500,000 ringgit to the seven enterprise. So it's quite, so this is one of the advocacy that we turn to the public, to the enterprise, to the small SME, that those doing against our Act 712, and those in terms of these price fixings, big riggings, or abuse of monopoly, so they can find up to 10% of their worldwide turnover. So those are two big cases that circulated in the media now, and so indirectly it will advocate to all of the enterprise that MYCC will take a stern and rigorous action against those against the Competition Act. Okay.
Thank you, Mr. Osman. But maybe just a follow-up question in terms of, because you have mentioned a couple of initiatives, and what's your, and the issues that you've encountered, what's the next step for MYCC in terms of, monitoring and measuring the effectiveness of these initiatives? Your next step action.
Well, the next steps, we have a couple of steps, and one of the major steps is we do quite, I would say, quite major in the amending our Act 712. That include one of the big issue is the merger policy. So currently, we haven't put merger policy in our Act 712. So it's being drafted, final drafted, and it will be tabulated in the parliament, or endorsed by the parliament. So it will be implemented and gazetted by our. So that's the big issue. Or that, other than that, things like we call the advocacy. In fact, we call the various enterprise. We call various agency. We do workshop. We call from the other competition authority. For example, we have a few workshops to the enterprise, to the SME, to the government agency, to the various stakeholders to show. And in fact, we inform them ahead about the merger policy, about the amendment of the Act, so that they are aware. So when they want to do merger next time, so they have to inform us, and we have all the thresholds. So if the threshold is limit that threshold, so we have to advise them, so they have to do this, and that.
Yeah. Thank you. So now let's hear also from Dr. Willard. I noted that COMESA has many stories in the conduct of advocacy initiatives. Kindly tell us the major initiatives, their objectives, and how you assess these initiatives. Dr.
Thank you very much, and let me congratulate the Competition Authority of Kenya and the co-chairs of this advocacy initiative for a very well organized function, and indeed I thank you also for inviting the COMESA Competition Commission to be part of you today and share some experiences. Now, we are talking about advocacy, and the way I look at advocacy is that it's the heart, it's the pump, it's the aorta of any competition and consumer authority. And I've observed in this journey that some competition authorities, or indeed consumer authorities, do not take advocacy as seriously as they take enforcement, for example. But my view is that advocacy is just as important as enforcement. Because, I mean, if you are just enforcing and the results of that enforcement are not well disseminated and no one knows about that, then it is as good as not enforcing. So that is what should be on our minds when we talk about advocacy. And then what comes in mind when you talk about advocacy is basically disseminating what it is that you do, what is the importance of that thing that you are doing, and what is the impact that that thing you are doing is bringing to society. Basically, those are the three issues that you look at advocacy. So I was chatting with someone, I said, we all know about Colgate, we all know about Coca-Cola, but Coca-Cola and Colgate are still up to today heavily telling us about what Colgate is, about what Coca-Cola is. So it's a continuous process again that you just don't do today, then tomorrow you end. Because even the Colgate and the Coca-Cola that is very well known, if today they stopped that aggressive marketing and advertising, very soon we'll forget about them. So it's the same with advocacy. It should be taken that very seriously. You asked me about the objectives in the case of COMESA, and I think which should be the case for everyone. The objectives are also very simple. The first objective for us is to ensure that there is enhanced compliance, and I'll explain on that. The second objective for us is to ensure that there is enhanced knowledge and awareness by those who are affected by the operations of the Commission or by the implementation of our laws. And then the third one is basically informing legal development and legal reform. So I'll take a bit of, maybe a minute to explain on that. Compliance, I think, is one thing I've already attempted to talk about. The more you engage various stakeholders, the legal community, which is what we've done so much, the legal community, the businesses themselves, the journalists, academia, what you are doing is basically creating knowledge in those people. Because sometimes non-compliance is not because people don't want to comply. It's because they don't know about what they are supposed to comply to. I heard, and unfortunately we are here in Kenya and in Africa. Before we used to hear that, no, in Africa compliance of laws is very bad. I don't believe that. Maybe it was bad because people are not aware of what they are supposed to comply with. I've seen this in my experience that with our advocates, we've engaged lawyers extensively, and the compliance levels is something you can clearly see. You don't even need a quantitative tool to see the increase from one level to another in terms of compliance. You just need to use common sense and your eyes to see what has been happening. Compliance levels have gone up. Legal reform and development is another thing. When COMESA commenced its operations, a number of countries did not have competition and consumer laws. But because we engaged in extensive advocacy with the governments of those member states, we have good number of countries now with competition laws. The chairperson of the Competition Authority of Kenya this morning, Shaka Kariuki, talked about Uganda coming on the scene with the competition and consumer law. I'll tell you that COMESA was extensively involved in that process, discussing with parliamentarians in Uganda, discussing with the executive in Uganda, explaining the importance of that law to the Ugandan economy. And today here we are, we have a law there. Then the third one that I spoke about is awareness. Awareness is very important because, look, if I'm not aware of my rights under a certain law, even when those rights of my rights are being infringed upon, if I don't have knowledge that I have those certain rights, then I'll never complain, or I won't know where to take the issue. Okay? So again, in competition law and consumer law in this case, we need those for whom the law is supposed to protect and defend, to understand, know their rights, know their obligations, know where to go when an infringement has occurred. And we have seen this in COMESA, that when we started, we had to look for cases. Now, people report cases to us as a result of that robust awareness. The next thing that you asked is how do we then tell that some of these objectives have been achieved? I'll be very honest here that currently we do not have any quantitative tools or instruments that we'll be using to tell. But we can qualitatively see that. As I said, we can see the increase in the number of lawyers seeking information on how to notify transactions or on how to engage with us where they are representing a client who's been involved in a restrictive business practice or conduct. We have also seen a number of countries who've been coming to us, seeking for help to develop their laws or indeed raise awareness about that law in their country. That shows that what we are doing is having an impact. What can we do better, finally? Obviously, there's always room for improvement. Like I said, currently we don't have any quantitative tools. I've heard I've learned that some authorities do have those tools. We are keen to learn on those tools and how they are using them to measure the effectiveness of that advocacy. But also on our part, one of the things that we are doing to make sure that we even become more effective in this endeavor is that we need to have a bigger budget for advocacy. And for the institutions that are here, that is my advice to you. Advocacy is not cheap. Just like marketing and advertising for Colgate and Coca-Cola is not cheap. So you need to invest lots of money if you want to see the returns in this advocacy. That's one thing we are doing. Secondly, in our case, we have now developed a dedicated unit called the Research Policy and Advocacy Unit. Whereas before each division was doing its own piecemeal advocacy, majors would do things on their own, restrictive business practices would do things on their own, consumer would do things on their own. So it was quite fragmented and it was not that very effective. To make sure that there is that effectiveness, we assembled one unit that is responsible for that, and I think it has worked very well. And then finally, among a number of so many stories that I can tell, but in the interest of time, finally, we realized that journalists are a very important element to this whole process of advocacy. So we brought journalists together from all the 21 member states of COMESA, from Eswatini to Tunisia, up there, all this chain. We brought together all those journalists and developed what we called a business reporters forum. And in that business reporters forum, the intention was that these journalists would be reporting about competition and consumer issues, disseminating that information. And also we've encouraged writing papers amongst those journalists on competition and consumer issues, which papers are then awarded. There's some award that is given annually. So I think I may end here for now. There's so much to tell, but probably if I'm still given a bit of more time later on, I can share other experiences. Thank you.
Yeah, thank you, Dr. Wemba. I think we have the same observation in the Philippines because SMME, among micro, small, and medium enterprises, are not really aware of the competition and policies. They don't know their conduct or behavior are already in violation of the competition law. And I think that's a good emphasis that advocacy will play or address that kind of issues. And I think one tip that Dr. Wemba said, especially maybe for young competition agencies, you don't need a very complicated measuring tools to measure the progress of your advocacy initiatives. No? I think, yes, he mentioned the number of compliance, you just count the number of compliance, and then among lawyers. But I just, one follow-up question, Dr. Wemba. If you could identify one advocacy initiative that you need to conduct differently or need to improve, what is it? What kind of advocacy is that? Because you have so many, I think, so many stakeholders.
Oh, it's a very interesting question. And before I answer it quickly, we do conduct advocacy initiatives among so many stakeholders. We have an annual judges workshop for all COMESA member state judges. We have an annual workshop for ambassadors and diplomats accredited to COMESA. We have workshops for lawyers in the common market. Every year, all these are things that we have. And then the journalists, as I spoke about, as I said earlier. But if I may isolate one from these that I've mentioned, I think we may do much better with the journalists. I know we created this researchers forum. I've seen a good friend of mine, Andreas, is here, and he's looking at me here because he's part of that business reporters forum. We created that, but I don't think I'm satisfied. I can confidently say it is yielding our desires or what we wanted to see. So I don't know, maybe there's somewhere where we need to refine. I'm not so sure what I can do now, obviously. is something that we need to discuss with colleagues in that forum, and as I said, Andreas is one of those. But clearly, and I think he agrees with me as well, that it does not appear that we are really getting exactly what we wanted. So maybe the journalists, we need to refocus and see how we can engage to achieve that intended objective. Thank you. Andreas, don't report me to them, please. But that said, I don't mean that they are not doing anything. Actually, there's still there's some work being done. And the issue may not be because of them. The issue may maybe be us. Maybe there's something that we need to do to make them see that this is the agenda, this is the vision, this is the objective, and it can be achieved in such a manner. So maybe it's from us.
Thank you very much.
Yeah. Taking into consideration our guide questions.
Okay. Thank you very much for this invitation, and I'm very pleased and very honored to share this panel with our colleagues and with all of you. And thank you very much, Kenneth, for your preparation for the panel, for your work. My first message would be advocacy is very important. Perhaps it's a very simple message, but I have a personal feeling that sometimes even in the ICN or in the national competition authorities, we are not very conscious about how advocacy really is important. I will say that because perhaps one of the advantages of working on activities on advocacy activities So this open activity implies advantages and disadvantages. Perhaps if you connect this definition with the idea of measuring effectiveness of our work, perhaps I will say that it is perhaps more disadvantages than advantages. I mean, when you detect a case, there is a collusion, for example, in the market, you know quite well what the final result. You detect them, perhaps if there will be a fine, and you will resolve the case. In advocacy, it's much more complicated. Right? You have to follow, for example, what we understand in the Spanish case, what we understand by advocacy is following any intervention, any public intervention in the market. This intervention can be, for example, through draft regulation. It can be when they go to a public tender, for example, when they gave aids, state aids, for example. So any public intervention in the market is affecting the market, obviously. And any of this intervention will be part of our work, it will be part of our advocacy. So I will just come back to my first message. Perhaps, at least in the Spanish cases, I don't know any other institution, competition authority, that could influence our government as we can influence in our government from an independent point of view, with horizontal view of any sector. So my first message would be take advantage of the opportunity, take advantage of the old advocacy toolkit because it's really important for our society and for our consumers. So my second, and that going to the point of your question, Ken, I would like to share with you a project we developed in the Spanish community between 2000 and 2022. And it was just focused on the idea of measuring our effectiveness of our recommendations. You know the motto, what you cannot improve, what you cannot measure. And that is a simple idea, but it's very effective. We try to measure our work from 2013 to 2019. during 6 years. The universe was quite complex, but there were more than 500 advocacy decisions and more than 2,500 recommendations. So this project, it was financed by European Union, also it was technical support, and it was developed by 2 external consultants. The idea of evaluating, of self-evaluating, perhaps it's a bit complicated to understand when you have to do by your own. So we thought it was a good idea in this case, because in 90% of our work, it is the CNMC who makes the work, and we don't use, we are not, usually we don't contract any external person, staff to do our work. But in this case, we thought it was a good idea that the idea of evaluation could be done by a third case. So the project was quite interesting because the objective was twofold. The first one was just, as you can imagine, it was to analyze the degree of compliance of our recommendations. And I had a very big surprise in that case, because personally, if I was asked what grade of compliance of our recommendation, perhaps I would have said that the percentage of degree of our recommendation would be 20-25% of all our recommendations were followed. Surprisingly, the project stated that around 60% of our recommendations were followed. So it gives an, let me to return to the first message. It was very important, our work for the government. And the government followed our recommendation in many cases, much more than we were conscious about. So that would be the first objective. The second objective of our project was to set a simple methodology in order to apply this evaluation in future cases. I must say that we were not very original in that at the moment, because we tried to follow the pattern stated by the OECD, and you know that there are some categories where you can allocate some of the barriers to competitions, etc. Well, it was simple, but it was quite effective to apply. So I would like to remark as well, because I think it is worth mentioning, that sometimes the first or the best reason you have to convince government, ministries, or whatever, the public sector in general, about your work, about your recommendation, is the economic impact of not following your recommendation. That is a simple message as well, but it's quite effective. So we try to apply this methodology in our project to 12 cases, and in a wide range of cases. There were public procurement cases, there were draft regulation cases, there were even state aid cases. And applying this methodology, we could reach a conclusion, and it was that around 2 to 2.3 million euros could be saved if we were to follow our recommendation. And in terms of lower prices, public expenditure savings, or shorter waiting times for consumers. So the simple idea of giving this economic data to the government was quite effective in order to follow some of the recommendations. And Kenneth, I don't know if you are, perhaps I can focus on the actions we could recommend, or you prefer just...
Yes, maybe just a follow-up question, because you've mentioned about compliance to your recommendation. And given the large and heterogeneous set of recommendations issued by CNMC, have you experienced difficulty in ascertaining compliance with and monitoring the effectiveness of such a diverse set of advocacy initiatives?
Yes, I would like to mention perhaps 4 kind of actions I would recommend to evaluate. I will put it in a scale perhaps from the most aggressive to the less aggressive, to the government, I mean. Perhaps the most aggressive would be to change, to transform, to have a change in our regulatory competition authorities in terms of to make our recommendations binding for the government. I know that it's, probably the government would not be happy with that, and probably it would be even dangerous in order to limit the political autonomy they will have to have. So it is an option. I wouldn't recommend it. The second one would be perhaps to make our reports mandatory and follow a principle known as the comply or explain principle. That is more reasonable. in order to have the possibility to express your opinion, to give your opinion to the government in any case that affecting the competition in the market. So the idea of having in mind the comply or explain principle gives you the opportunity to know exactly what reasons the government has in order not to follow your recommendations. So it is a very valuable information because, in fact, in our case, in the Spanish case, we have the opportunity to challenge before court some of their decisions. So if we know the reason why they are not following our recommendation, we have an important information because we can go to the tribunal with a more complicated defense of our case. The third one will be to show the, well, I mentioned before, to show the profit loss for the general interest of not implementing or not following our recommendations. No? My background is in law, but economists are very familiar with this idea of the economic impact of not following recommendation will be an amount. And this amount you are losing, consumers are losing this amount. So it's a simple idea, but it's very effective as well. And the final one would be to make our recommendation more clear. Some of the information the project gave us was that sometimes government didn't understand our recommendation because the government was asked as well why are not to following the recommendation in some cases. And as an example of self-criticism, I will say that our recommendations are very important, but they must be very clear. If not, you have a high risk of not complete the results. I will stop here.
Maybe just one follow-up. Just for the benefit of our audience, can you tell us one advocacy tool that works best for CNMC?
We are now developing some of these actions. In fact, we are trying to evaluate some of the advocacy decisions we have made in the past. And we have been evaluating some kind of state aid regimes affecting, for example, electric vehicles. So we are trying to give an input to the government in terms of your aids were effective or not. So from an advocacy point of view, not from a simple to follow with the European Commission, we have to follow as a member of the European Union. So the idea of measuring your work, I think it is now permanent in our annual plans. So I think that is the main message just to share with the audience.
Yeah, thank you, Juan. So before I entertain questions from the audience, may I invite our speakers if they have follow-up remarks. You want to follow-up remarks before I entertain a question?
Maybe just want to add something that I forgot to say earlier about the one of the good things about the monitoring activity that we do. Not only is to see what are the success factors of advocacy interventions, but also it's important for us to ensure that there is a coherent action by the authority over time. Because we've been gathering data for 10 years now, and so things change, people change inside, and so it's important. But sometimes, recommendations are also about very technical details and of markets. So you need to be sure that your recommendations are consistent, or if you want to say something different, then it must be motivated.
Yeah, go ahead, please. Go ahead.
Thank you. I think for mine it's just a reiteration and emphasis on the importance of advocacy, and that for your authorities, because remember we are created and we are put in those offices to make a difference. So the office is not about me as Willard Mwemba, being the CEO of the Commercial Competition Commission. It's about what impact, what benefit do we bring to society. So advocacy is one of those tools that you can use effectively to show that impact. I'll give a quick example in 10 seconds, 20 seconds, Kenan. That, for example, currently we are talking about high food prices, food inflation. And in poor countries, that's a very big issue. Most people, the big amount of their budget is spent on food. So when you have high food prices, it's a very big issue. And at the Commercial Competition Commission, we've been doing this study, and I think my colleagues later on will talk about it. It's called the Africa Market Observatory. And in that study, we are doing it in conjunction with the University of Johannesburg. In that study, certain issues have come out which are pointing to reasons why food prices are skyrocketing in Africa, okay? And we know about them now. But if the report will just end in my office and it will not be known to those people who are supposed to make change, then it's useless, right? So that's an example of what advocates should do. It should be known to those who can make that change, policymakers and the like. Then the last one, please use journalists effectively. They are a very good tool in this business of advocacy. I spoke about them. One of the things that you asked also was, are you able to see change? Yes, we've seen that. There have been lots of reports about the CCC Commercial Competition Commission, about the fines that we impose, the prohibitions that we do on certain transactions. There's been a lot of reporting on that. And why? It's because journalists are engaged and they've gotten that interest in appreciating and understanding what we do. So that would be my advice. Journalists, please bring them closer. They are a very good tool in this advocacy business. Thank you very much.
Yes, go ahead, Mr. Rosman. You wanted to say something?
Yeah. Okay. Thanks, Dr. Kenneth. In Malaysia, in my CC, so we evaluate the effectiveness of the advocacy program qualitatively and quantitatively by using different methods. Yeah? One of the methods is we have a survey and feedback, and in our websites and in our portal we have a survey and feedback from all of the parties, from all the stakeholders, so the public can have can in the survey and the feedbacks based on what we have done and what we're going to do it. And on top of the survey and feedback, we have education outreach programs. So in fact, we collaborate with a few university and the legal lawyer departments within the university. So we educate them what is the competition law, and even though it's new, competition law is new in our region, but by using that kind of advocacy to the law students, so they are aware of that, of this competition act and competition policy. And on top of that, as the other panelists mentioned about the media and coverage, of course, things like the chicken feed case, that is a big boom case in our country where it's a 5 enterprise. In fact, those are public listed company. It's a worldwide company, so it's a big, I would say it's a billion turnover. So there's a multi company, and of course it will give a deep impact to their company and to the mass market as a whole. So that's be part of the advocacy to the people as well. So thanks again to media and journalists. I believe media and journalists is here as well, and they will help us to advocate the competition policy to the mass as well. And on top of that, we have the complaint and reports. So we receive all the complaint and report from the public, from the mass, and we evaluate them. And all the complaint and reports, so we have, whether it's against the competition or it's not against the competition, we have to analyze every single reports one by one, and we give feedback to all the complainants. And if the big case again, so we have to make a public announcement to the media as well. And on top of that, last but not least, the one I mentioned just now is the act that we're going to amend. It's a big amendment to our act that includes the merger, and of course, on top of that, digital economy is a new area to us, and we are still developing, and we are still, I would say we still need to learn from all of the senior competition as well. So thanks again.
Thank you. Since we started late, I think we can afford to entertain 2 questions from the audience. Anyone who wants to? Yes, sir. Go ahead.
Dr. Mwemba, you mentioned that the CCC has some room for improvement. You mentioned a few areas, one of which was quantitative tools. So as an antitrust lawyer, I'm wondering, what are you referring to? Are you referring to econometrics and economic experts and in-house, computer crunching, number crunching computers, quantitative in that sense, or quantitative in the sense that your co-panelist mentioned, which was, he said very poignantly, you can only improve what you can measure, or you can't improve what you can't measure. You mean quantitative in that sense, as in your impact from the advocacy, or quantitative as in measuring merger efficiencies?
That's a I'm laughing here because I don't have an answer to that question. But look, as I said earlier, this issue of advocacy should not be a complicated issue that someone should be bringing in econometrics, computer crunching or something like that. And that's why I said I've heard this, that there are certain authorities, sometimes authorities talk about we have these quantitative tools in measuring the effectiveness of our advocacy. I'm yet to learn from them how they do that. That's what I said, so that if it is something that we can implement as well at the CCC, and if it's effective, then we can adopt it. But frankly, currently, we don't have such a tool, and it's very easy for us, as I said, to see what is working and what is not working. We had no reporters talking about the CCC in 2013 when we commenced our operations. We, even now when you go on just Google, you will see so many reporters writing about the. It's very easy to see that that is working. We had very less compliance. Andreas, you remember, very well being an antitrust lawyer, that there was lots of resistance to the compliance to the commercial competition regulations. I see lawyers voluntarily coming to us now, asking about what they should do, about compliance and the like. It is something you can see with the eyes. So in our case, to tell you the truth, we think we are able to tell what is working and what is not working. However, I mentioned the quantitative tools again. Remember, as she has just said, we need to keep on evolving and improving. If there are those that are using quantitative tools, as I've heard, which I don't know about now, I have no knowledge of. If there are those that are doing that and it can help us to improve, I would love to learn from them. That would be my answer. Thank you very much.
Yes, ma'am. Last question.
Thank you very much to the moderator and the panelists. That was a very good session. Well done. My question is to Dr. Willard, and just borrowing from the example you've given us of the Coke, I'd like to just, pick your mind on what more you think we could do, really to take this advocacy to the level of Coke, the example you've given us. And to also probably ask you, do we really have the appetite to take this advocacy subject to that level? And in case the answer is yes, is there hope that we will get there, the Coke thresholds? Thank you.
Thank you. My answer is very simple. Getting to the Coke threshold is what I said. You should make sure you understand that advocacy is not cheap. So please have proper budgets for advocacy. Us at the CCC, we've invested so heavily in advocacy. But I'll tell you that the returns are very good as well. So that's one thing we should think about if we have to get to the Coke and Colgate levels. Is there appetite? Appetite should be there if it's not there. And how do you create appetite? If internally within our institutions, as I said, there should be this conscious recognition that we are there in those offices to make a difference to society. And if one way I make a difference to society is prohibiting anti-competitive measures, it is to prohibiting and bursting cartels, I should then explain the importance of those prohibiting those anti-competitive measures and bursting those cartels to society, so that society appreciates why I'm there, and society ultimately helps me to implement that. Because if society appreciates that cartels are bad, it will be the very same society that will come and report to me when there are cartels happening in the market. So the appetite should be there, and that appetite will be created by us who are in those offices by appreciating why we are in those offices in the first place. What was the third question? Sorry. Should have been. Is there hope? Yes, of course, hope is there. And if I'm to buttress the reason I'm saying hope is there, you would see what we are doing from the Commercial Competition Commission. I think we've done, you don't sound your own trumpet, but I'll tell you that we've done commendably very well in this advocacy issue. The country where we are here, where do you come from? From Kenya, yeah. The country where we are here, the Competition Authority of Kenya, is very aggressive when it comes to those advocacy issues. So the hope is there. Maybe what we need to do now is to extrapolate, amplify this to the entire Africa. If we are to talk about Africa, it's to the entire Africa. But there are few countries, COMESA itself, CHA itself, I've seen a few other competition and consumer authorities that are quite aggressive. That hope is there. What we need to do is to keep the fire burning so that it spreads. Thank you.
Okay, so our time is up. As much as we want to discuss more about this issue, we need to close this session. So please join me in thanking our speakers for sharing their expertise and experiences. Thank you very much.
Thank you very much. As they take a photo, I'd like to remind us that the program is available on our badges. You scan the QR code, you'll be able to access the program. So we're now moving on to breakout sessions 1, 2, and 3 that will take place here. So we're going to partition this room into 3 sessions. So breakout session 1 will be on this side, which is Loita. Breakout session 2 will be in the middle, which is Siana. And breakout session 3 will be on the end, which is Talek. Breakout session 1 is about advocacy toolkits that address concerns and spur MSMEs entry and participation. Breakout session 2 is on analyzing effectiveness of advocacy toolkits. And breakout session 3 is on cross-cutting enforcement jurisdictions, enhancing gains from collaborations with sector regulators. So you'll just allow us 10 to 15 minutes to set up, then we can sit in the 3 breakout sessions as you would prefer. Thank you.